Padjadjaran. We are looking forward to the wonderful lecture delivered by our honorable speakers, as well as fruitful discussion from our honorable participants. Please allow me to introduce myself. My name is Selamat. I am a law student from Faculty of Law Universitas Padjadjaran, and I will be your master of ceremony for this public lecture. On behalf of the host, we would like to extend our gratitude and greatest appreciation to each and every one of you for being able to join this event. Before we start the webinar session, please allow me to explain some of the webinar guidelines. First, please mute your audio during the session. You may activate your audio during the Q&A session. Second, we recommend you to activate your video. Third, please follow the instruction to change your username, which is your name _ institution. Fourth, you may deliver the question through chat, and if you wish to deliver it directly, please use the raise hand function in the participant menu. Today's webinar will be divided in sessions, which are the first session is presentation of material by Ms. Dyah Paramitha, and the second session is presentation of material by Dr. Harald Sippel, and the last session will be the Q&A session. Before we start the session, we would like to introduce Dr. Prita Amalia.S M.H as acting on duty on behalf of Head of Transnasional Business Law Department. Dr. Prita will deliver welcome speech for today's webinar. For Dr. Prita, the screen is yours.
Thank you very much, Yella, for the introduction, as well as with the time to say something in this public lecture. First of all, I would like to welcome Dr. Harald Sippel and Dyah Paramitha, our alumni, for today's public lecture with the topic recent issue on first major and hardship. I believe that this today's topic is really relevant since post-pandemic or in the pandemic COVID-19, we always discuss about these principles in terms of the implementations of the international contract law or transnational contract law. Dr. Harald and Dyah, we are very happy, and it's a great honor for us to having you in this public lecture. If I may introduce this new department, Transnational Business Law Department is quite new for the Faculty of Law. Maybe when Dyah as a student, we didn't have this kind of department. So this Transnational Business Law Department was established on 2018, and as a response in the issue on the economic, trade, investment, and contract law. Since the topic of the issue is dynamics, so I think the Faculty of Law needs to respond with this department. As we see in the profile or the video in the early of this event, there are some subject. I think this subject is really important today, especially in the transnational business law or transnational business activity. So hopefully in the future, we would like to, we're very happy to have another collaboration in the future with Dr. Harald or Dyah as our alumni to be, to give another lecture or session to meet with our students. And this is a part of the comparative contract law subject in this department, and some of student or participant for this public lecture will be from the undergraduate student as well as with postgraduate student. So I believe that all the students are very curious about this topic, first major, hardship, and sometimes we also discuss what are different with the frustrations. So hopefully all the students could use this valuable opportunity to discuss and to understand further about this principle, especially in the implementations of the international contract law. So once again, thank you very much and welcome to our Faculty of Law virtually, and hopefully we will having you in our campus, and happy to welcome. Thank you very much once again. I might apologize if there is some inconvenience in the preparations or today's lecture. Thank you so much to Pak Gary as our head of international unit, who always facilitate public lecture, especially international public lecture, and to Sela and all the committee. Thank you very much and enjoy the sessions.
Thank you, Dr. Prita Amalia, for the welcome speech. Ladies and gentlemen, please allow me to introduce our speakers, Ms. Dyah Paramitha and Dr. Harald Sippel. Ms. Dyah Paramitha is a senior associate at Hogan Lovells DNFP. Good afternoon, Ms. Dyah.
Hello.
We also have Dr. Harald Sippel. Dr. Harald are the founder of sippel.legal and also adjunct lecturer at Kelo University. Good afternoon, Dr. Harald.
Selamat siang.
Selamat siang. Without any further ado, we will start the first session. I will hand over the floor to Ms. Dyah Paramitha. To Ms. Dyah, the floor is yours.
Thank you, Sheila, Pak Gary, and Bu Prita for the opportunity. Actually, the honor is ours, yeah, Harald. I mean, like, we are very happy to be here, and we're very happy to share what we have in the knowledge experience that we have with you, especially students, because like before we open the floor for everyone, we had a discussion before this session, and we actually like to share knowledge, exchange ideas, brainstorm, and things like that. And it's something that myself and Harald have in common. So when the invitation came to me from Bu Prita and Pak Gary, Harald is top of my mind. I already know that I need to get Harald on board, and I know that he will be on board. So yeah. So for today's session, we will be talking about force majeure and changes in circumstances, I would say, and it would be I'm going to give you a bit of theoretical background. Maybe you already know, but I'll be like going into more theory and more into how is it done in Indonesia based on several case laws. And then Harald will, and I will also give like just a snippet of what is frustration under common law. And then Harald will continue on to give you more practical approach, more how is it done in practice, how to apply the theory that I explain later on in the session in practice. So I'll start to share my screen. Wait a minute. Can you see my screen now? Good.
Yes, Ms. Dyah.
All right. Oh yeah, by the way, you can call me Didi or Kak Didi or whatever. Like, don't be too formal with me because well, I'm an alumni too. So just treat me as your friend. So like I said before, we will be discussing about force majeure, or in Dutch overmacht, and hardship. So hardship is something that is unique because in a way it's usually translated or applied by Indonesian courts as partial force majeure or like relative force majeure because of the structure of the law does not provide like a legal foundation for hardship on its own. So usually it's the court will use force majeure clause to connect the hardship into applying it into in practice. So we're going to talk in more details about the theory. So the first section will be about force majeure. Force majeure under Indonesian law. Sorry, I made this presentation in a hurry, so I did not have the time to translate it into English. But you can read it in Bahasa Indonesia. I can explain to you in English, and we're gonna have a discussion. So if anyone has any question in the meantime, you can or do you have, if you have any like burning ideas you want to discuss, you can just go on and raise your hand on or try to put it in the chat and we can discuss. So yeah, force majeure. So force majeure under Indonesian law is provided under the Indonesian Civil Code, the Burgerlijk or BW. It's in Article 1244 and 1245, basically. But the key for force majeure is actually the release from obligation. So basically, if you have a contract and under that contract you have obligations to do so and so or to not do so and so, so you will be released from that obligation. In Indonesia, we call it perikatan. So under a contract, perjanjian, you have obligations, you have perikatan, and you have, and when something happened that is not anticipated, that was not your fault, not that person's fault, not anticipated and not expected, that person may be released from his or her obligation to perform. And the key is actually that if someone did not perform his or her obligation under a contract, he or she will be under a position of breach, in which if you breach a contract, there will be consequences. And under Indonesian law, it is this. Can I use the? No, I don't know how to use the pointers, but basically, if you did not perform your obligation, you will be in a breach of contract, in which you will have to compensate the costs, damages, and interest. Like you can see here in 1244, you have to compensate the costs, damages, and interest, unless that person can prove that that obligation was not performed or cannot be because it is because of something that is beyond his or her control. So if that is the trigger for, this is a force majeure, the trigger for saying that a force majeure has occurred, basically. And in 1245, it is like repeated that cost, damages, and interest is not being like he's not going, he or she, the person who did not perform his or her obligation, is not obliged to compensate the cost, damages, and interest if it is because of a force majeure or because of something that he or she did not intend for that occurrence to happen or for that force majeure to happen. And then we move forward to the next section in Indonesian Civil Code that talks about force majeure. Now we go to 1444 of the Indonesian Civil Code. So basically, it says that if the object that is being if the object of the agreement of the object of the contract is like vanished, gone, it's no longer there, like you can no longer rely on the existence of that object to perform, then that obligation to perform is like basically also like erased or like removed, as long, so there's like a comma there, as long as the goods or that object was vanished or like it's gone and it went beyond control, not because of your like that person's fault and not because of that person's doing, basically, and that person whose obligation is like, you know, like erased, like released from its that situation, there is that to perform and make him or her cannot do whatever he or she is supposed to do under that obligation. So, and then we talk further on 14.45 of the Indonesian Civil Code. In 14.45 of Indonesian Civil Code, we're talking about something else, like if the person like who's supposed to perform that obligation cannot perform, and for such because of that situation, that person is released from his obligation, but that person can make a claim to someone else due to the due to that like impossibility to perform. For example, if you we're talking about mortgage, let's try to take an example of house mortgage. So when you take a mortgage for a house, you have to pay the mortgage for the house like in installments, for example, for 10 years. And then when you sign into that mortgage, there you will enter also into an insurance agreement with an insurer for basically for stuff that you cannot expect to happen. So like fire or natural disaster, things like that. So when you sign into that insurance agreement, you will have a claim to the insurer if there's something happened with the house, basically. If it got fire, or if there's like God forbid, if there's earthquake and then the house like fell down and everything. So the object of the agreement between you and the bank or the financing institution is frustrated, or like it's no longer there. You have insurance claim, but that insurance claim will have to be like will have to be surrendered. A successful insurance claim will have to be surrendered to the person to have the obligation to pay it to. So this is how basically how it goes in practice with this 14.45. And then we go further a little bit more to force majeure under the UNIDROIT. So this UNIDROIT is not, I would say this is not hard law. It's more soft law, more of principles that you can choose to agree to use or choose to follow, but it's not mandatory. It's not statutory. The UNIDROIT has like lots of they do a lot of research, and one of the research resulted in the UPCC or UNIDROIT Principles for Commercial Contracts. I already shared this presentation to Pak Gary and Bu Prita, and maybe they can share it with you. But when you get this document, you can click here and you can access the UPCC 2016. This UNIDROIT has been like ratified by the Presidential Regulation 59 2008. And basically, if you found like you were in the position in which maybe this is a force majeure, maybe this is not, like I don't know what to do, and you want to consult like a tool, like how is it supposed to be analyzed, or how is it supposed to be assessed, you can consult this document, and you can also even choose when you're in a negotiation with a counterparty, you can even choose to adopt the clauses into your contract. So let's see what UNIDROIT says about force majeure. So the rules of Commercial Contract 2016 say that force majeure is whereby a non-performance by a party is excused if that party proves that the non-performance was due to an impediment beyond its control. So it's similar. So it's quite similar to 1244, 1245, and that it could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract. So basically, you like the example that I gave before about mortgage, they already like expected, oh yeah, Indonesia people might like you know house, usually there will be accidents like fire, earthquakes, things like that. So they put insurance policy at the front. So they might have expected that to happen, but it's not something that you want to happen. So you put insurance at front. But then, but when a situation is something that you cannot reasonably be like expected, or you cannot have taken that into account. Like, for example, what happened with COVID-19, nobody expected that a pandemic would happen in early 2020. Like, nobody would have expected that to happen. And people already make plans 1 year, 2 years ahead, plans that they cannot basically, they can no longer do according to what they have planned sometimes, and that might be that, depending on how you word your force majeure clause in the agreement, that might be a reason to say that it is a force majeure. So and in this UNIDROIT principles, basically it's breaking down force majeure into several smaller like chunks that you should analyze, like whether a force majeure had happened or not. So and we're going to talk about types and the nature of force majeure in later sections. But here you can see in clause 2 of Article 717 is that if that impediment is only temporary, the excuse to not perform, I'm adding that explanation there. So if that impediment is that situation of force majeure is only temporary, that excuse will only have effect for the period as it is reasonable for that person to not perform. If it's still possible, it means if it's still possible after that temporary impediment, then you will have the obligation to perform again. But it will be it will also depend on how the other party sees and or how the actual wordings you have in your contract, because sometimes sometimes we see in contracts, and we when we're in a negotiation, we see people say in their contract, and they put it very firmly, that if a force majeure happens for more than 90 days, for example, or more than 180 days, then the party who is not affected by the force majeure is entitled to terminate the contract, basically. And the parties can then agree also on what is the consequences of that. Like, will that mean that the termination will be ex nunc, or will that mean that the termination resulted in an ex tunc annulment of the agreement, like the whole thing must be reverted, or what? So it depends on what you agree in your agreement, and that's a matter of practice, basically. And maybe, I don't know if Harald, maybe he will also discuss about that later in his session. And then in section 3 here, the party who fails to perform because of that impediment, the party who suffered from the force majeure, the occurrence of the force majeure, must give notice to the other party and of the force majeure and how it has affected him or her on its ability to perform his or her obligation. And in practice, we see that the parties usually put this also in writing in the agreement, like how long should you notify the other party if a force majeure happened, like usually 24 hours or 48 hours after such force majeure, you have to notify the other party through what means. So basically, if communications, if you're in the middle of nowhere, there's no communication line, then how do you inform the other side? So basically, you will need to agree about that part in your agreement. but you have to notify the other party that you cannot perform your obligation anymore, and it has to be served in a reasonable time, in which allowing both parties to understand the situation and how it has affected their contract. So in section 4 is we're talking about what I have discussed before, that sometimes parties can also agree that if a force majeure is occurring for a certain period of time or over a certain period of time, then the parties will have an option to terminate, and what is the effect of that termination. Then we move forward to the then we move forward to the elements of a force majeure. So what is a force majeure, and how can this incident be considered as a force majeure or not? So this is a summary of various sources. So I'm using the Indonesian Civil Code. I'm also using the books from the writings from Satrio, Subakti. Also, I also saw like a restatement of force majeure from the Supreme Court's website. And this is like a synthesis of it all. I make it into like 4 big chunks so that it's easier to digest for you, because I realized that the audience will be students mostly. So I hope this simplifies your life. So basically, for something to be considered as a force majeure or as an overmass, it has to fulfill these 4 elements. The first one is that it should be unexpected. Like, you should not have expected that this will happen when you close the contract. So you cannot. So the debtor of that obligation, the person who has to perform that obligation, cannot be forced to be liable for what happened. And that person who has the obligation to perform has no bad faith or has no intention for making that situation happen. And like it should be shown that he or she, that person who has the obligation to perform he or she does not want this to happen as well. So it's something that is beyond expectation. That's element number 1. Then element number 2, that what happened, that thing that happened, the incident or that force majeure event that happened, impede or restrict that person from performing his or her obligation. So because of that event, so there's an event, number 1. Number 2, that event causes him or her to, like, he or she can no longer perform his or her obligation under that contract. It can be that the obligation cannot be performed because of the object. Because of the object here means that the object is gone, vanished, like it's no longer there. Like, for example, if you are agreeing to purchase a plot of land and then there's landslides, the land is no longer there. Like, you don't know where are the borders of that land anymore. It's gone. You cannot have an agreement on that anymore. Gone. That's the obligation is cannot be performed because of the object. And then the second possibility is that obligation cannot be performed because of the subject, or because of the person who is obliged to do that obligation can no longer perform. For example, because of new regulation or new law has been enacted that prevents him or her from doing that obligation. So and basically, if he or she continues that obligation or continue to perform, then he or she will be under a position of breach, statutory breach, which is worse than contractual breach. So that impedes him or her from performing that obligation. And then number 3, another element for force majeure is that there is no fault or there's no like intention to do something wrongfully, or there's no there's no negligence from the person who uh, who can no longer perform that obligation. So that event in number one is not caused because of that person's fault or that person's negligence. And then the last element is that situation cannot be expected or anticipated, or you, anticipated when you enter into the agreement. So basically, when you don't know that there will be a new law issued in the next 2 years, and you have a 5 years contract, and then in the second year, 2 years down the line, there's a new law saying that you can no longer do that business, basically because it has to be so and so. It has to be it has to be performed by a company who is limited or something like that. So basically you can no longer perform. You can it's not something that you could expect in the beginning of the contract, and you cannot close the risk or mitigate the risk through getting an insurance policy or something like that. Then basically all of the situation happened, the force majeure event or the force majeure situation happened just right in front of you. It just happened unexpectedly. You cannot expect that there will be a tsunami tomorrow or something like that. So it's something that you that person who has the obligation could not be reasonably have expected to happen. So those are the 4 elements of force majeure. And now we go to the types of force majeure. So sometimes people categorize the types of force majeure into their contract. So if this type of force majeure happened, then this is how you mitigate them. If this type of force majeure happened, this is how this is what the consequences are. So in the types of force majeure can be grouped or into put into 3 different buckets. The first one is based on the cause. It can be natural disaster, it can be emergency situation, it can be change of law, based on the cause. And second is based on the nature of it, it can be a permanent impediment, it can also be a temporary impediment. And can also and there's force majeure can also be categorized based on the scope. It can the impediment can prevent a person to perform obligation in its entirety or only partially. So depending on how you put the clauses, the force majeure clause into contract, you can try to anticipate, if force majeure might happen, it can happen, everyone knows it might happen, but how do we anticipate the consequences of that? Then you can try to, for example, if a war happened, I want this, then you need to list down what happened if there's a war. Okay, the party who suffered from that situation must notify within how long? And then is there any workaround on how that person can continue to perform? Or if not, then what happened? Will it end up in a termination, or will it end up in a release of that obligation only, and the other obligations continue to be applicable? So it depends on how you word your force majeure clause, and I think Harald will be talking into more details on that. And based on these types and based on how you see and how you project the risk of your contract, you can try to minimize the consequences or the the risk that comes from a force majeure situation in your contract. Then now I want to talk about some case studies. So I mentioned before about COVID-19, and this is a decision of the District Court of Tebo, number 1 of 2021. And in that District Court decision, the Court of Tebo said that the COVID-19 pandemic is a force majeure. So that force majeure, so this case is about a cooperative. So members of the cooperative inserted, like they contributed money to the cooperative, and they expected that their money will be returned, their investment will be returned within a certain period of time. And then it didn't happen because of the COVID and the economic situation back then. It's just impossible for the cooperatives to perform to the level that they expected before. So they performed, but their performance was not to the level expected by these members of cooperatives, who expected their investment to return, and they also expected profits from that investment. And then the cooperative uses COVID-19 pandemic as a defense. Like they use force majeure as a defense. I cannot perform because of this COVID-19 pandemic, and basically that is approved. Like the court accepted that the COVID-19 pandemic as a force majeure that impedes the cooperative from performing its obligations to the level that is expected by the members of this cooperative. So that's one. Second one is the decision of the Supreme Court, C4 2016. In this Supreme Court decision, actually, the one I put in bold and in quote is part of the considerations of the Supreme Court. So basically, they state that the right to build document. So if in Indonesia, like if you want to build a building, you need to get the right to build document from the relevant government authorities, and the non-issuance of that right to build document is not a force majeure, and it cannot be used as a reason to release a person from his or her obligation. That's basically the principle introduced in this Supreme Court decision. So initially, the Medan Religious Court said that the non-issuance of the right to build is a force majeure, but then after an appeal, the higher religious court of Medan of North Sumatra issued another decision that is overruling the first religious court decision and saying that no, it cannot be a force majeure. Like the non-issuance of the right to build is not a force majeure because it does not fulfill the elements of a force majeure as set out under 1244 and 1245. Now let's go back to 1244 and 1245. What do they say? So they say it's caused that impediment is something that is unexpected and there is no bad faith, and it must not be like something that is beyond the control. It must be something that is beyond the control of that person who has the obligation. While in this Medan High Court, higher religious court decision, they say that no, it's within your control to get that right to build document, basically. So you can still perform, you can still do, or you can still try to obtain that right to build this document. So it's not a force majeure, and that is approved by the Supreme Court. Now we go ahead to the changes, basically hardship, changes in circumstances or hardship. So under Indonesian law, basically we do not have a certain or an instrument on its own that that's talking about hardship or changes in circumstances. But as also mentioned before, like in passing in the first major section, we have ratified the statute of the UNIDROIT, and in the UPCC 2016, there are principles related to hardship that we can we can on a case-by-case basis try to apply or try to refer to when we have no other reference, basically. And again, this is not hard law. So let's see what the UNIDROIT Principles 2016 say about hardship. It is in 621, so the contracts to be observed. So basically, if there is a situation that makes parties in an agreement who initially were on equal footing, but because of that situation, now they're no longer on equal footing, like the one party has a better leverage or better position in comparison to the other, the performance under the contract continues to be as it is. Like, you cannot change it unless there's hardship. So what is hardship? You go to 622 then. What is hardship? So hardship is basically a situation that fundamentally alters the equilibrium of the contract. It's just, and that situation usually, you can see here, it's that situation happened after the conclusion of the contract. You cannot reasonably have taken that into account when you close the contract. It's beyond the control of the party who became disadvantaged because of that event, and the risk was not assumed. So you cannot initially kind of anticipate it or try to like insure it or things like that before. Some example of this is what happened in the oil and gas industry in 2015, 2016. Maybe more on the gas industry, because like as we all know, like in 2011, there's a big nuclear disaster in Japan, in Fukushima. And what happened after that is that the demand for LNG spiked. Like the price of LNG went crazy high. And but after that, in 2014, 2015, the situation changed like crazy. Like oil price dropped to like somewhere below 50, I think $50 per barrel. So it went below that, from over 100 to below 50. So what happened is that people started buying oil again and no longer have interest on gas. And what happened back then, the price of LNG, who already got expected to be high by 2011, 2012, 2013, dropped into like a very like crazy price in very low price in 2015, 2016. You cannot have reasonably expected that to happen because based on history, it has price always goes up, like it never goes down, but it happened. So what happened then was it's like if you do your research, like you can try to Google it. A lot of players in the LNG industry are talking about price review clause and how they can use the hardship clause if they have it in the contract, or hardship doctrine if they don't have it in their contract, to alter or to renegotiate their contract. So basically, that's like part of what could happen in this situation. So it's like, for as an example. So the hardship is the situation where a party may not be prevented to perform, like he or she can still perform, but if he or she continues to perform, it will be just impossible for him or her to continue to stay in that situation. Like it's bleeding him or her dry, basically. So, and while the initial intention for parties to enter into contract is to mutually benefit from that contract. So when that contract no longer mutually benefits both parties because of a hardship situation, if you have this clause in your contract, or if you kind of want to consider to renegotiate your contract, you might want to resort to this hardship principle. So in 623 of the UNIDROIT Principles EPCC 2016, you can see that in case of hardship, like I mentioned before, the disadvantaged party is entitled to request renegotiation, and that request must be made without undue delay. So and down here in section 4, you can see that basically the number 2 and number 3 is like you can request on good faith, but the other party may say like, well, you already agreed, it's binding, it's party's agreement, it has to be honored, things like that. And you can, or they can say, yeah, this is sanctity of contract, you cannot change it. But then you can resort to court or to the judicial or the forum, the dispute resolution forum of your choice, if you want to kind of use hardship as an argument to renegotiate a contract. If you do that, if you go to dispute resolution forum, then the court or the relevant dispute resolution forum might choose or might make a decision whether to terminate the contract with an X mark effect, like from that point onwards, or whether the court or the dispute resolution forum of their choice can also make an instruction or an order that parties should like renegotiate in good faith or to adapt the contract with a view of restoring its equilibrium. So now this situation is like the hardship situation, like we discussed before, is often also recognized as a rebus sextantibus. What is this doctrine? Maybe if like it's a saying in Latin that is not very well recognized, but we hear it very often in the last couple of years because of COVID. So an agreement is valid and continues to be enforced if the situation is still the same when the same as when the agreement, the contract itself was entered into. So basically, if there's any change, that the agreement may not be valid and still enforced. So we see this like the direct position of rebus sextantibus. We can see it in law number 24 of 2000, that if there's any fundamental changes in circumstances that affect the performance of the contract, then the contract is terminated. But as a note, I put here that this is only applicable to international treaties that falls within the definition of international treaties under Law 24 2000. So in commercial contracts, it might be different. In commercial contracts, there is no like statutory instructions or statutory instruments, I mean, that says when there's fundamental changes in circumstances, the agreement or the contract will be terminated. There's no such thing. There's nothing that is to the level or to the strictness level introduced under Law 24 for international treaties. So in commercial contracts, what happened would be what the parties would agree to happen, and how the parties in that agreement try to put the equilibrium back into their contract and the performance of their contract. Now we're going to talk about how hardship is applied by Indonesian court. Okay, 5 minutes. Okay, I'm almost done. So how Indonesian courts apply the hardship principle. So basically, the hardship situation gives room for the parties who suffered from that disadvantages to change or to work around from the obligation it has under a contract. So here we used an example from the Denpasar Industrial Court. The Denpasar Industrial Court basically said that hardship is a relative offerma. So it's a relative force majeure. It's not a force majeure that caused you can no longer perform in its entirety. You can no longer perform to the level you are expected under a contract, but you can still perform. So what happened here is that this is a lawsuit from the employees of a hotel, or if I'm not mistaken, a hotel or a resort. They were terminated. Their employment contract was terminated. And before that termination, they were not paid to their full salary. And when they were terminated, they did not receive the full severance package. So basically what they do here, what they did in this lawsuit is that they sue for the full amount of their salary and for the full amount of their severance package. The hotel management, basically the hotel said that, oh, cannot do that. I cannot pay you to the fullest. What I've provided to you, well, when we terminate you, is already the best that I can do, because I'm in a hardship situation because of this COVID. I cannot basically pay you to the numbers that I want to, or numbers that we agreed in our contract, but this is the best that I can do. And this is accepted by the court. So hardship prevents you from performing to your fullest, but this hardship allows you to be released, maybe partially, or give you a leeway to alter your obligation under a contract, basically. And just frustration, and I'm going to just talk a little bit about frustration under English law. So it's actually quite similar, not exactly the same, but quite similar. But force majeure is introduced by the French, if I'm not mistaken. Harald can fill me in a bit later in his session. So basically, frustration is a doctrine to set aside a contract because of unforeseen event that causes that contract can no longer be performed, or changes the fundamental situation between the parties when they close the contract. So this doctrine was introduced in the Taylor and Caldwell case. So basically, here, both parties, the one who leases the music hall and the owner of the music hall, are released from their obligation. So here, see, both parties are excused. The plaintiffs from taking the gardens and paying the money, the defendants from performing their promise to give the use of the hall and gardens and other things. And consequently, the rule must be absolute to enter the verdict. So basically, both parties are released from their obligations to perform under a contract. And I think Harald can fill me in a bit, can fill in about frustration under common law a bit later in his session. And that's all I have for you, I think, in time. Right. Thank you.
Thank you, Ms. Dyah, for the presentation. Next, we will hear the presentation of material from Dr. Harald Sippel. Dr. Harald, the floor is yours.
Thank you very much. Before I start, let me just thank all the great people from the university, including Dyah as an alumna who invited me. It's my great pleasure and honor to be here today and speak about this topic. And as we discussed prior to the session, I also do hope it's not the last time I will be invited to speak, but the first time. But this is up to me now, because if I give a boring presentation, then probably you will not invite me back. And with that, let me share my screen. And something I hope that will make this, my part, more exciting is that I intend to touch upon several practical issues, because at least for me, those are really the ones that are fun, because this is real life. But all the while, please do keep in mind that without the first part that was delivered to you today by Dyah, it's not impossible to discuss the practical issues, because you first need to understand the theory and everything that really matters in order to get into the points that play a role and then discuss them accordingly. Also, one last point before I start. I do appreciate that there is a Q&A session at the end, but if at any point in time there is a question you have, if there is an issue, maybe I speak too fast, I'm not loud enough, you know, whatever it is, please feel free to interrupt me. I'm very happy to adjust accordingly. So I structured my lecture into two parts. As Dyah already pointed out, I will first speak about frustration and put it in relation to force majeure. And my second part is really the issues that occur in practice. What can you see here? What are issues we have been dealing with in 2022? Which industries are affected? What can go wrong, etc. Now, why do we mention frustration? Dyah has already pointed out it is a common law doctrine. And if you want to say so, it is the equivalent of force majeure in the common law world. But it's really just the equivalent. You cannot say it's the same thing. Force majeure, when it comes to statutory law, only exists in civil law countries. It's originally a concept that derives from Roman law, where it's called vis major, major force, and has been adopted, as far as I understand, by civil law countries all around the world. But the common law world, as some of you may know, has taken a very different path. Since I'm from Europe, I can tell you that the British often take a different route. And that's the same for the legal world as well. And there is nothing right or wrong about this. It's just different. So frustration is this concept. What is frustration? Let me briefly highlight that to you. When we look at the Cambridge Dictionary, and I'm just giving you a dictionary definition here to make sure we start with the very basics. Frustration is the feeling of being annoyed or less confident because you cannot achieve what you want, or something that makes you feel like this. And I'm sure all of you have felt this way from time to time, sometimes because of very tough lecturers who give you a lot of homework or who give you very difficult exams, sometimes for other reasons. It doesn't matter. This is the term frustration in daily life, but it also has a second meaning, which is the fact that something prevents plans or efforts from being successful. And as you may have guessed, this is more the definition that's relevant here for our purpose, for the purpose of frustration. So when we look at frustration as a legal concept and not just the daily life language, we can define it as an unforeseen event which either renders contractual obligations impossible, that's the first possibility, or it radically changes the party's principal purpose for entering into the contract. Now, let me highlight a few points here. Unforeseen event. It is something that when the parties entered into the contract, they did not envision. The point here really is the time you enter into the contract. You cannot say you enter into a contract before the pandemic, and there are obligations that need to be fulfilled throughout the pandemic. At some point, it was clear clear that you could not fulfill those obligations. But what's relevant is the point of entering into the contract. And as Dyah has already pointed out, really no one expected the pandemic to happen, at least not at this time. There are several people who highlighted that the threat from pandemics is growing, but really no one foresaw that it would happen at this time. So this is really what an unforeseen event is. There is the impossibility. You cannot perform your contract anymore. Dyah has done very well in highlighting the difference between it's becoming harder, that's hardship, and it's becoming impossible. And for frustration, it's also this impossibility that matters. However, there is also this alternative element, which is it radically changes the party's principal purpose. So this is already which makes frustration quite different from force majeure, but I'll speak on that in a short while. I just wanted to highlight to you the principal points here. The major case that Dyah already highlighted is Taylor versus Caldwell, and that's an English law case. It was about the rent of a music hall for concerts. So imagine that you want to organize concerts, but you have no place to do that. At least in a country like the UK, where it's often cold, you need to rent a hall. Doing it outdoor is too dangerous because most of the times of the year you couldn't do it. So you need to rent a music hall. And what happened in this case is this music hall burned to the ground just a week before the first concert out of several concerts was supposed to happen. And strangely, the owner of that music hall still sued this organizer and said, you haven't paid your rent. And when I first came across this case many years ago, I was asking myself, how stupid can people be? Because really the hall has burned down and you're still asking for rent. It makes no sense, right? But keep in mind that this is common law, and in a common law contract, usually everything needs to be written in the contract. And if it's not in the contract, then there are fewer concepts of, I put it in very plain terms, what makes sense, what is logical, what is fair, what is unfair. This applies much less in common law than it applies in civil law. So in principle, the owner said the risk that the concert cannot take place was a risk that those who organized the contracts assumed. In other words, they were ready to take on that risk. And now that risk has materialized, so they are still liable to pay for the rent, even though the hall is no longer there and you pay rent for something that literally does not exist anymore. So when it came to the judge found that there was a contract, but this absolute liability that I just mentioned, it does not apply because there can be either an express or an implied condition that's in the contract. Now, what does this say? Sometimes a contract says subject to blah, blah, blah. This is an express condition, and only if this subject to is fulfilled, then the contract enters into force. I can tell you something very specific from a contract that I personally signed recently. It's a contract to join a Malaysian law firm. And one of those conditions says I have to be fully vaccinated. So what this means is, and against COVID-19, of course. So what this means is I have to give evidence to my future employer that I'm fully vaccinated. And only if I can show that, this condition is met. If I cannot show that, then the contract will simply not enter into force. Here, the judge said there are certain underlying conditions which are in the contract. And the judge said, even when they are not expressed, but only implied, they can still exist. Here, the existence of the music hall. And by the way, the picture of this building on the top, this is the very music hall we are speaking about. The existence of this music hall is an implied condition, because in the judge's logic, and I think this really makes sense to you, unless the music hall exists, you don't want to rent it. And that makes perfect sense, right? Because you don't want to rent something that doesn't even exist anymore. So this is why the judge found that the fire was neither party's fault. And he took an analogy from Roman law and French law, and then came to the conclusion that neither party is under an obligation to perform. All obligations ceased to exist. Now, let me highlight a few similarities between force majeure and frustration, and then also highlight differences, because I think that's very helpful for you to understand and put these into concept. What's the same thing is a bad bargain is not frustration. Now, what does bad bargain mean? You just made a bad business deal because you did not anticipate that suddenly there was going to be an increase in prices, and originally you expected a profit of 100 from this contract. Now suddenly you have a loss of 50. This is a bad bargain. This is not frustration. It's also not force majeure. The unforeseeability requirement must be there. I already mentioned that before. The impossibility requirement. Again, and I'll speak about this later in greater detail, impossibility does not mean that it's harder. That's just it's being harder. Impossibility means it's not possible. There is no obligation to perform, because under force majeure and frustration, if it happens, then neither party is under an obligation. And it's both in statutory law. Now, this does not mean that you cannot have a frustration clause. It does not mean that you cannot have a force majeure clause. Of course you can have them, but these two concepts, they apply as a matter of statutory law. So even if you do not have them in your contract, if you are in a contract with English law, Australian law, New Zealand law, etc., frustration will apply. And if you are in a contract with Indonesian law, French law, Austrian law, the law of my home country, force majeure will apply, even if you don't have it in your contract. In spite of these similarities, there are many differences. Frustration happens automatically. There is no need to make a declaration. Frustration is automatic. If the contract is frustrated, you do not need to notify the other party. It includes changes of circumstances to some extent. You will recall that I said this alternative is the radical change of what the parties had in mind. And this is much more similar to what we commonly call hardship, or also the Latin term would be clausula rebus sextantibus. And finally, the frustration of purpose is required under common law. And I want to highlight here just one point where this really applies. In practice, because of an event, you sometimes have a delay, sometimes you have an excessive delay. Now, let's assume that you are a ship owner and you are supposed to ship fruits. Let's say it's pisang, Indonesian bananas. You are supposed to ship them from Indonesia to China. Now, if there is a delay of 2-3 days, this could very likely be force majeure. If it's, let's say there are floods, the harbor is damaged and you cannot load those bananas. Now, flood would generally be a force majeure event, and you are excused for these 3 days of performance because there was the flood, and it's not your fault that you cannot load the banana onto your ship. However, after 2-3 days, your bananas will still arrive safely in China. But let's put this in contrast. Is it frustration? No, it's generally not frustration because the purpose of the contract can still be met. 2-3 days does not damage the bananas to such a huge extent that the contract cannot be performed anymore. However, let's use an excessive delay. Let's stick with my example. There is floods, the harbor is severely damaged, and you cannot load the banana at all. It takes 3 months. Now, within those 3 months, all the banana are going to go bad. I think we can all agree on that. Even if it's the best quality bananas, they will go bad eventually. In this case, the contract is frustrated because you could still those bananas, but what you could deliver is something that's rotten, something that has gone bad. So here, the contract would be frustrated. It would also be force majeure because the force majeure event, the floods, happened in any event. But you see the difference here that in the case of a short delay, it would be force majeure, but it would not be frustration of the contract. But in case of excessive delay, it would usually be frustration and force majeure. So it really often depends in practice on the specific circumstances why or whether we can say a contract is frustrated. And in this respect, force majeure has a lower threshold because the moment there is even a short delay from a force majeure event, then force majeure would apply. This is it for the theoretical part. Now let's jump into practice. And what I'd like to do also when jumping into practice is I'd like to pose questions to you from time to time, but please don't worry. I'm not going to I'm not going to pick anyone specifically. And also, please keep in mind that there is no right or wrong. I just want to explore some issues with you to make this more fun and more entertaining. And fun, of course, does not mean that we are just laughing here, but it's just more interactive. Now, what force majeure events exist in practice? Can anyone, or does anyone want to say something or write something in the chat? And if you paid attention to what Dyah said, then you should be able to at least say a few of them. Anyone out there? Yes, Quina Shia, sorry, I hope I pronounced it. You raised your hand. Thank you so much.
Yes, my name is Quina Shia, and force majeure events access when there's some disaster event that make the contracting parties impossibility to perform the contract.
That's wonderful. Thank you so much. But don't mute yourself yet. But I'm looking at a specific event. Now, what would have to happen so that we can say it's impossible to perform the contract?
Maybe if I have a contract with you, like you rent my house, and then when you live in my house, the house is burnt because of because there was a fire, but it came from the outside.
Right. Very good. Thank you so much, Quinashia. So your force majeure event would be fire. Does anyone have any other force majeure event? And this is really easy, guys. You can earn brownie points with your lecturers now because those are really simple questions. Come on, who has another force majeure event? Jaslyn, you raised your hand also. Thank you so much. What's your force majeure event?
Probably the COVID-19.
COVID-19, excellent. You paid attention during Dyah's lecture. Thank you so much. One more person. I'm asking for one more force majeure event. Now, if this were an in-person lecture, what I would usually do is I would bring Austrian chocolate And whoever gives the right answer gets some chocolate. I cannot do that now, I'm sorry. But if I ever speak at the university, I promise to bring some sweets to the students who participate. Who else dares naming one force majeure event? Darian, go ahead.
Okay, so maybe an example I found is in a contract for a band performance. So a band has to perform. If one of the members got into an accident, that would be a force majeure. They would not be able to perform.
Okay, so one person has an accident. Yes. Wonderful. Thank you so much. Thank you to all three of you. Most of the events you mentioned, fire, COVID-19, although COVID-19 goes both ways, but also accident, we often call them act of God. It's something that just happens. And this is the common understanding of force majeure. A major force, something really big happens. So we usually have this perception that it's something that we really cannot do anything about, and humans have nothing to do with it. I'm here to tell you that as much as this is what we believe, this is not what happens in reality. In reality, sorry, and I just mentioned flood, earthquake, tsunami, volcano eruption. Those are also those acts of God. In reality, most force majeure events are man-made, and this may really surprise you, but let me highlight why I say that. You all are aware of the ongoing war in Ukraine, and this is just one part of the world where there's wars. There are many other countries. An accident, if Darian, you mentioned the accident. Now, if the accident is caused by negligence, then arguably this is man-made, right? This is not an animal jumping onto the road. That would more be an act of God, or, well, we could say an act of an animal, but no one says that. But if it's negligence, imagine you are driving and then you're on your mobile phone and you crash into another car. This is really man-made. Sanctions. You've probably heard of many countries which have imposed sanctions against Russia and other countries. Imagine that you are a producer of spare materials for aeroplanes. You cannot sell them to Russia anymore if you are from a country which has imposed sanctions against Russia, because it has become illegal to do that. And this is man-made, right? There are government orders. I'll get into that in a minute. Basically, a sanction is also a government order. That's just any law or any decree. But I want to highlight sanctions here differently because those have been so popular in recent weeks and months. There are often strikes. Imagine that you want to deliver your products from your factory somewhere else, but there is a strike and all roads from Bandung are blocked and you cannot go anywhere. Is this an act of God? No, that's all humans. And there are many more. I just want to highlight that so you are aware. What have we seen a lot in 2022? Let me highlight that. We have seen a lot of government orders, and I'm highlighting one government order in Indonesia. As you may be aware, Indonesia imposed an export ban on palm oil. Now, imagine that you are a producer of palm oil, and in that case, you would usually export it to other countries because domestic demand is only that much, but production is that much. Suddenly, you cannot do that anymore. India has recently been in the news. You see, I copied those news articles just this morning when I was finalizing my slides. This is a week ago. India has recently imposed a wheat export. So Indian producers of wheat cannot export wheat anymore. And Malaysia, where I live, starting, I think this is today or yesterday, has imposed a ban on chicken. Chicken can no longer be exported abroad. So we can all eat the ayam goreng here in Malaysia, but Singapore cannot anymore because a lot of the Malaysian chickens go to Singapore. And above all, the most important government orders in 2022 were lockdowns in China. The zero COVID policy has really been very, very damaging and caused a lot of force majeure situations because no one in China, at least from these affected areas, could export anymore. We have really seen a lot of force majeure events because of war and sanctions in Ukraine. Most recently, this was just yesterday, the EU announced another sanctions package for oil. So now Russian oil can only be received through pipeline. This will cause force majeure to many contracts because when it's illegal, you cannot be forced to do it. Even though physically you could still do it, it is illegal, and this is the same as impossibility. And then something that will still affect us for several years to come are supply chain shortages. Now, what is that? Let me briefly highlight that. Imagine that you are a seller of cars. Let's say cars, because I think most of you are at least somehow familiar with cars on a basic level. And I think most of you know the car manufacturer Mercedes-Benz. Now, Mercedes-Benz does assemble cars in Europe, but the parts to assemble those cars really come from all around the world. And this is basically called the supply chain. There are suppliers from all around the world, and they ship their products, sometimes raw materials, sometimes intermediate products. They ship them to factories in Europe. And what we have been seeing now for about a year is that there are shortages in many parts of supply chain. I think you have heard about the semiconductor or the computer chip shortage. This is really affecting many industries. And we are seeing many, many force majeure declarations because of that. Now it also affects the food and beverage industries, palm oil, for instance, wheat, chicken, all of that is food, right? Many companies are incurring a lot of costs, and this is really a very important topic at the moment. And I'm really just highlighting this so that you can put the theoretical part that you heard from Dyah in a better perspective so that you understand how this plays out in real life. Which industries are affected most? Does anyone, well, I'm not gonna ask that question now because you can see an oil pump here. I was gonna say, does anyone have any idea? But that's too easy now. Now, let me briefly highlight this. The ones which are most affected are, or is the energy industry, oil, gas, electricity. Why is that? Now, that's a tough question, and I'm going to answer it myself. It's because there are often long-term supply agreements. Imagine that you are a producer of oil in Russia, and you build a pipeline all the way to Western Europe. That's going to be a few thousand kilometers. Now, you will only build that pipeline if you know that you can supply gas for a very, very long time. Because building the pipeline costs so much that your contract is only going to be profitable if you know you can do that for a very long time. And what applies to oil also applies to gas and to electricity. It's just very expensive to build the infrastructure needed. So you often have those long-term agreements. And this is why these industries are most often affected. It's just that those contracts last for a very long time, so much more can happen. I think this makes a lot of sense to you. If I sell you my mobile phone, it's very hard that there is force majeure, right? Because I give you the phone, you give me the money, and that's it. Boom, we have a contract. But the longer something takes, the higher the risk of something happening. However, as much as it's generally the energy industries that is most affected, it can be any industry. We have seen agriculture, and everything I highlighted on the food and beverages industries goes there. We have, sorry, that should be vehicles, not vehicles. That's a force majeure mistake on my part. But also baby formula. This may sound very strange to you, but you may be aware of this baby formula milk, which is replacing the breastfeeding. In the USA in April, there was a baby formula crisis because in one plant where this is produced, they found, or they thought that they found some bacteria which supposedly killed someone. And this plant was shut down for a long time. And because of supply chain shortages, also other deliveries could not be made. And suddenly there wasn't enough baby formula milk. It's crazy, but these things exist. And I'm really just highlighting this to you to showcase that it can affect really any industry. Now, what are common misconceptions about force majeure? Again, you were very fortunate because you had all the theory at the beginning. But not everyone has the advantage of listening to Dyah give a lecture on force majeure and hardship on a daily basis. So in practice, there are many misconceptions, and I'd like to highlight some of those. One of them we've already touched upon several times. It's impossibility on the one hand and higher costs. What we see in practice, and much of what you will see on the screen, is something that I have been seeing as a lawyer in my practice as a lawyer. You see one side telling the other side, our energy costs have increased substantially, so we cannot perform anymore. Now, this is certainly not good because as Dyah has highlighted, energy costs have increased substantially in recent months. But does it mean that you cannot perform the contract? Of course not. It just means that it's much more difficult for you, much more burdensome, that's the term we would use, to perform the contract. The costs of containers is so high now. If you want to ship something from China to Europe or to the US now, it costs between, it costs between 12 and 18,000 US at the moment, one single container. Shipping it back costs less than $1,000. You see there's a huge price difference, but this is because the lockdowns happen in China. There is a huge demand for containers at the moment, and they should be shipped out of China to Europe and to the US, where people buy the goods as quickly as possible. Again, does this mean that it is impossible? No, it does not. And some people say this has completely changed the bargain. This at best could be hardship. There is a fundamental change of circumstances, but it's not force majeure, because force majeure would require impossibility. And again, I want to highlight here, performance must be impossible. Then we speak about force majeure. And in case you were wondering, while I put the palm fruits here on the picture, well, when Indonesia stopped exporting palm oil, then the price of palm oil increased substantially on the very same day. So this is why I have the picture, just in case you're wondering. There is also impossibility on the one hand, and other than what we planned. Something I've seen recently by a client is they said, we wanted to transport this by train, but now we need to do it by ship. This is much more expensive. Yes, again, I understand that it's much more expensive, and I understand that you wanted to ship it by train, but your contract does not say anything on that. Your contract only says you will deliver. So this is not impossibility. When the contract does not specify from where delivery has to happen, this is often other than planned. Delivery of 100 metric tons of palm oil does not say it is Indonesian palm oil. And even if the seller is from Indonesia, it only says 100 metric tons of palm oil. You can purchase this palm oil in Malaysia, in Thailand, if you cannot purchase it in Indonesia. So it is still possible to perform the contract. The same for 50 tons of grain. If you are an exporter of wheat from India, but your contract does not specify that it should be shipped from India, then unfortunately it's bad luck for you, because wheat from India is not different from wheat from another country. And likely this is going to make your contract much more expensive, likely or not likely. It is very different from what you have planned, but it is not impossible. So this is also a common misconception. And again, I'm highlighting performance must be impossible. Finally, a third misconception, force majeure is not force majeure. And this doesn't make any sense when you read it on the slide, but let me highlight what I mean. Very often a question is, who is affected, and has performance truly become impossible for that company? Now, the picture I chose here is from an earthquake, but you can see that who's really affected, at least on the picture, are the two houses in front, while the building in the back, it does not look like it has sustained any damage. And very often this is what happens in real life when there is a major event. A disruptive event affects someone, but not everyone. And often companies complain that the suppliers say this is their get out of jail for free card, like when you play Monopoly. But this is not what it should be like in real life. In real life, you really have to look at all the facts, and you really have to determine, is this company really affected? And is it really impossible for them to deliver? Now, if this company had their factories in the building in the front, then I think we would all agree that this building has been destroyed, and likely the machines have been destroyed, and it has likely become impossible to perform the contract. But if their building is the one in the back, then it doesn't look like there is any damage, and they should still be able to perform the contract. So in every force majeure situation, you really need to look at the specific facts. And this is when disputes occur, because you really need to see this one specific company, is it the one which cannot deliver anymore? I want to highlight here that numerous Ukrainian companies, even though war is ongoing, they continue to perform the contracts. There is one Ukrainian company which is exporting steel, and in the past, they have always done it through ships, through the harbor in the Black Sea. Now, all harbors in Ukraine at the moment are blocked, so they cannot do that, but they now do it by train, and they now do it through rivers. It is still possible. Now, keep in mind that war is ongoing in Ukraine, but still, you really have to look at all facts. And please don't see this as me being cynical about the war in Ukraine. This is terrible, what's happening there. I'm really speaking about this from a purely legal and contractual perspective here. Now, I want to share with you what a force majeure declaration looks like in practice. Dyah pointed out that this declaration needs to be made. And I also mentioned that frustration is automatic. Force majeure, you need to make a declaration. And I just wanted to highlight something, what it looks like. This is something which was made in April 2022 of this year by the Dow Chemical Company. It was available on the internet. That's where I got it from. And I just want to highlight, they say here, there are circumstances beyond their reasonable control. They are unable to supply. Now, those are the two most common elements we see in declarations. They say beyond our control and impossibility. And again, not just harder to perform, but impossible. And they also highlight here the reason for force majeure is their inability to obtain certain raw materials. This is those supply chain disruptions that I mentioned before. Now, what's missing here, and I'll speak about that, is they don't really highlight how long they expect the situation to last. In my opinion, it's something that should be there, but it's not really a legal requirement. But I'm telling you this because I'll speak about it later. I'm really showing this to you because when we speak about force majeure and force majeure notices, force majeure declarations, I believe you should have seen one in practice, just so you know what it looks like. What are problems we see in practice? One major problem is simply bad force majeure clauses. What do I mean by bad? The parties often copy from here and there, and their contracts look like this carpet, which has all different colors. You put one part from here, one part from there, and you end up with a contract that's just really bad. This applies not just to force majeure, but to any clause. But some parties copy parts of force majeure clauses from here and there, and at the end of the day, no one understands what is meant. Sometimes it's really just bad English, you know. And I'm not a native speaker myself, but when I am in doubt, I ask a native speaker. Commercial parties often don't do that, and you simply don't understand the contract anymore at the end of the day. Sometimes, and this is my biggest criticism of the common law world when it comes to force majeure, they use a finite list. Now, what is that? They say in the contract, force majeure shall mean war, sanctions, floods, and fire. Now, they say that because this is what they think of when they enter into the contract. Numerous contracts had such force majeure clauses, but they did not state pandemic. And simply because of that, there was no force majeure, because according to the contract, only those items listed constituted force majeure. So in my view, having a finite list, meaning a list where you say this shall be force majeure and the rest shall not be force majeure, it's bad drafting, because by default, you're always gonna forget something. Maybe one day there will be an alien invasion. Now, you think right now this is crazy. I also think it's crazy, but a few years ago, we thought it would be crazy to have a pandemic of that scale. What should happen very soon, but has not happened yet, is a solar storm. I'm quite sure you have not heard about this before, at least some of you. But if it happens on a large scale, then we will not have any electricity for several hours around the world. Now imagine what this means for contracts. How many contracts do you believe have solar storm as a force majeure event listed in the contracts? I believe it's less than 0.01%. So this is why I believe it's a big problem in practice, and we often see that. I list here, if you have those 4 items, and usually it's a lot more, but what about explosions? You know, is it a fire? Is it not a fire? if you put your force majeure clause this way, you are just asking for trouble. Another common problem is notifications. Dyah pointed out that they need to be made within a specific time. In practice, they are often made too late. But what is too late? What if you are one of those companies that was placed in Fukushima, where nuclear disaster happened and the tsunami? Are you in a position to make a force majeure notice when your office is literally being swept away? Those are questions that really arise in practice. How much can you do in your specific situation? Often force majeure clauses contain no useful information. I give you a highlight here. I've seen this also in practice. We inform you that there is a force majeure event. We cannot deliver the goods you order. We apologize for the inconvenience. If you read this, you have no idea why there is force majeure. It just says there is a force majeure event, but what is it? Imagine that you ordered those goods and you urgently need them. How would you feel? In this situation, you really get very upset and angry and frustrated, and you just possibly want to sue them. It's even a question whether something as generic as this can be regarded as force majeure. I'm not sure how much time I have, but I think I have very little time left. So I'll stop here, but highlight something for you in case you are interested in learning more on force majeure as it occurs in practice. I created a LinkedIn group at the beginning of the year, which is growing on an almost daily basis. And I'm posting there on a daily basis on practical force majeure matters. For instance, I recently posted, this morning, I posted about lack of government intervention. In this case, it's a miner from South Africa, and there is illegal mining in its mine, and the police doesn't do anything about it. Even though they have obtained court orders, the police doesn't stop it. I posted about palm oil in Indonesia this year. I posted how companies feel when they are in a force majeure situation. I highlighted those import costs that I mentioned to you. And last but not least, I also spoke how declaring force majeure can affect your relationship with your customers. Because keep in mind, when you declare force majeure, on the one hand, it means you have no obligation to deliver. On the other hand, it means that your client does not get the goods they ordered. And this is now not the legal side of it, this is the practical side, really. Your client is likely going to be very unhappy, and it raises questions whether your client wants to keep doing business with you. Imagine you order something and you need it urgently, and suddenly you receive an email that says, sorry, force majeure, I cannot deliver. You wouldn't be happy. So I'm highlighting this to you in case you want to learn more. I put the URL here on the screen, but it's the only force majeure group on LinkedIn. So if you simply type force majeure on LinkedIn, you can become a follower. You don't have to, of course, and it's all free of charge. So as much as I'm advertising this, I'm not asking you to buy anything, don't worry. But if you want to explore this further and get a better understanding, then by all means, please do join. And with that, all that's left to say is terima kasih banyak. Thank you very much for your attention. And now back to the organizers. Thank you very much.
Thank you, Dr. Harald Sippel, for the very insightful lecture. Honorable participant, you may now present your question. Please click the raise hand function if you wish to deliver the question directly, or you may deliver your question through the chat box. Okay, we have Labit. You can deliver directly.
Thank you, Sheila. First of all, before I want to deliver the question, I would like to say thank you to Professor Sippel and especially Kadidi for the amazing insights. My question more so relates to Mr. Sippel's slides. You mentioned despite force majeure being widely known as an act of God, it is often man-made. And you also mentioned the reasons with some of those being war, sanction, and especially government orders. My question here, and I've been curious about this ever since like last year. Would a sudden economic downturn, let's say like the recession in 2008, or maybe like the 97 Asian crisis, maybe like the 2019 COVID pandemic, I'm talking about the financial downturn, not per se the pandemic, the literal pandemic. Would that constitute as a force majeure? Because let's say there's a franchisor and franchisee, there's an agreement to open like X amount of places, and then they have trouble getting the loans because the financial situation is not that good. Would that constitute as a force majeure? It's because I haven't found like a stable pattern. Looking into like the decisions, some courts say yes, some courts say no. I would also like to invite Kadidi because I would also like to know what the situation is in Indonesia regarding that. Thank you.
Didi, do you want to go first on Indonesia, or should I start?
It's up to you.
Okay, then I'll start and lay the grounds. Okay. Now, Labib, thank you very much. It's a great question if you ask it the way I believe you ask it. but let's see, because on the one hand we have to differentiate between it's harder to do business, and the other one is impossibility to obtain bank loans. Yeah. Now, as far as I understood, in your scenario, the impossibility to perform the contract would be the impossibility to open new, let's say, restaurants. Let's say this is McDonald's or whatever it is, Now, in theory, or not just in theory, let's look at what this would be like. You want to open new branches, but in order to do that, you need the financing because all of this costs money, but you cannot obtain the financing. Now, under normal circumstances, this is really up to you, and it's your responsibility to make sure that you have sufficient funds to do it, because there is no practical or legal impediment. Mm-hmm. Now, if we assume that the parties understood that for the opening of those new branches, loans are needed, and banks, as a matter of principle, do not give out any loans, or as a matter of principle, do not allow the opening of bank accounts, which are necessary for the opening of new restaurants, for instance, then this could be actual impossibility and not lack of funds. And this could amount to force majeure. I can give you maybe an example to highlight this, a recent example to highlight it and put it, it's a little bit similar. Which was the country? Colombia. A company from Colombia recently purchased oil from Russia. And they ordered the oil before the war in Ukraine started. And by the time the war had started, the 3 tankers were already on the way. And one was close to reaching Colombia because, it takes a very long time from Russia all the way around the world to South America. Now, when the Colombian company wanted to pay, it was not possible to do so in US dollars anymore because this was a payment in US dollar and it was Russian oil. And according to news reports, the banks that were involved all refused to do the payment in US dollars. Now, at the end of the day, this amounts to a lack of funds, because although you have the funds available, you are not able to use those funds. So it is a lack of funds, right? In this situation, the buyer of the Colombian oil declared force majeure, because by not paying, they would have been, it's a little bit more complicated than that, but I simplify here. It involved a letter of credit and all that, but I don't want to go there. But they would have been in delay to make the payment, because really they could not pay. But again, the difference here is that they were all the way ready to pay, and it's not that they just had no funds available. So I would really differentiate here, and I hope that clarifies. So to summarize, and sorry I'm speaking so long, but to summarize, my short answer would be, it is not force majeure if you just don't have the money. But if it is somehow implied that you need to get loans to do that, and that's the common understanding of the franchisor and franchisee, and often there is participation in profits, and sometimes the franchisor also provides some financing. You know, it can get more complicated than that. And in this case, it could very well be force majeure.
Okay, so maybe to add to that, like from I'm going to give you more on Indonesian law perspective. So we go back to 1244 and 1245. So what do you have in your contract? Depending on what is written in there, like you have, so for example, I don't know what it says, but for example, if you have to open 10 branches within the span of 10 years, so one branch each year, and for each branch you need to get funding from this bank. So maybe it's from bank or financial institution. So if it's set out very strictly in the contract, and then like and it also set out like the time frame where you should, when do you have to secure your financing, when do you have to open the branch, like it has to be on every 2nd of June of every year. So you have to open 10 branches on the 2nd of June for the next 10 years, for example. And then that happened, like the situation whereby like right now, the Fed raises its interest rate. It's crazy everywhere. Like all the financial institutions all over the world, and it's making it's not impossible for you to get the loan, but it just doesn't make sense. You're in a position of hardship, not in the position of getting a force majeure. It's harder for you to perform, but is it impossible? Maybe not. Maybe it's not force majeure. It depends on how the real life situation is. And also, if we go back to the Indonesian Civil Code 1244, 1245, you are only released from your obligation, and also you are released from being in a breach of contract if that situation is beyond control, beyond your control. So what you can do in that kind of situation is to resort back to what you have in your contract and see what is your options. Like, do you have to declare force majeure? Do you have to renegotiate? Because this is hardship. Like, it's impossible for me to perform the way I should have. So I want to renegotiate this, and you can because we're back. What we are discussing here, force majeure, is related to contract law, so it's back to the parties. But in the situation the simulation of the situation you gave to us, I don't see it as a force majeure per se. And it has to be like, depending on what is written in the contract, depending on what you have agreed before and how the wording is in the contract, the way to react, or the way you should, the actions you should take, it would really depends on that. Does that answer your question?
That answers the question. Thank you very much.
I'd just like to make one really small addition further to what Dyah said. There is case law out there which found that even when the costs increase by 300%, so keep in mind it's 3 times as expensive now, it's still not force majeure. And keep in mind what this means. You know, it's easy to say 300%, but keep in mind what this means for your business. If you have a profit margin of 10%, for many industries, that's very high. You know, the construction industry operates on a much lower margin. And suddenly costs increase by 300%. It's crazy. It's a complete disaster for your project, but still it's not considered force majeure.
I see. Thank you very much, especially for the example there. Thank you very much. I think that answers the question.
Okay, for the next question, maybe Darian.
Okay, thank you very much. I'd like to pose a question to either of the speakers. We discussed a lot in this webinar about events that restrict the performance itself. But what about events that decreases the value of performance? Say that you're a distributor of palm oil and you make a sale contract to buy palm oil with the intent of reselling it abroad. Now, because of the ban on export, you can't really sell the palm oil you've bought. But the ban itself doesn't stop you from either buying the palm oil or to pay for the palm oil itself. So since there is no longer a point in buying the palm oil, since we can't resell it, does that event qualify as a force majeure or frustration if it doesn't directly restrict the performance of the contract?
You want to go first, Harald? Or?
I'm not sure I fully understood everything because there was an interruption.
Oh.
But if I understood correctly, there is an obligation to buy the palm oil, but you know you cannot sell it on. Did I get that correctly?
Yes, so it doesn't ban the performance, but reduces the value in doing the performance itself.
Okay. Again, is there any impossibility to perform? I'm throwing the question back to you, Darian.
Let's say in this case, there isn't any.
Exactly, and that really answers your question. However, when it comes to frustration, the answer could very well be different, because you could say if it was an implied or explicit term of the agreement that this would be sold on, for instance, you're using an intermediary to sell something, then maybe you could say the contract became frustrated. But it really depends on the circumstances here.
Yeah, and also like the situation you just gave us is it's not force majeure. You stated yourself that the parties are not prevented from performing their obligation, but the value you reduce. So what happened there might be hardship, but even in hardship situation, you're not supposed to, like, you're not released from your obligation actually, because if you saw the case case example that I gave before, the case study, hardship is not force majeure. Hardship is only a relative overma, so it's not permanent, and it's also depending on how it affects the situation between the parties. It's not normally will cause you to or allow you to change the way you perform. So basically, when you're in a situation of hardship, or almost hardship, maybe you have the obligation to pay for something or purchase something that is way above what you expected it to be, or way less of what you expected it to be. So the value just change. It does not release you from that obligation. Unless you can show, or unless you can prove, and unless the other party can also accept that situation prevents you from performing to the level that you're expected to. So in a situation you explained, no force majeure.
Okay, thank you very much for helping me understand the concept.
I think there's another one, yeah, or two.
Next, maybe Adiana.
Thank you very much for the opportunities. These questions, maybe I proposed for either the speakers, and it has correlation with the materials of post major that the speakers have explained before. Well, it is might be specific cases that I found in the article in internet that US has given a sanction which prohibit their consultant firm to give accountant services or guidance and management consultation to the Russian. Well, I found that McKinsey and Corporation as an American global company management consultant has worked together with the state-owned companies in China, and they were with the Rostec company, a weapon maker in Russia. Since US already gives that such sanction to the Russia, the sanctions also applies as a law that is binding to the US entities, which is cause a limitation for these entities to enter a contract with the state-owned companies in China and with the weapon maker in Russia, or it's just some of quality measure that the US government has conducted. I'm still confused about this existence of sanctions, whether it is applies as a law or it is something that outside the law that is not binding for the national entities. Thank you very much.
So your question is actually more about what is meant by this US sanction?
Yeah, I'm sorry, I couldn't hear you properly. Could you?
All right. So your question is what is meant by this US sanction? So it's more on the US sanction, the nature of the US sanction itself.
Yes, that's the next question. Correct.
Okay, so I think Harald already gave a very thorough explanation about this US sanction. It is their policy. So it's a policy issued by the US government that restrict further business or any dealings related to the Russians because the Russians invaded Ukraine. So it's on the implementation itself is if you do not follow this sanction, basically there will be your business. If you have anything, any business in the US, you will like get maybe more like economic or administrative consequences. So what happened includes the firm that I am working in right now, Hogan Lovells. We did have an office in Moscow, and we have to close our office in Moscow so that we can continue serving our clients in the US. So that's what happened. So maybe Harald can also add to that. This sanction is not like it's statutory. It's something that issued by the government. But if you don't follow it, then so be it. You don't have to follow. You don't have to obey it. If you don't obey it, then there will be effects with your business. There will be impact to your business or whatever happened if you have anything going on in the US. So Harald, maybe you can add to that.
Yeah, thank you, Tidi. Well, I'm not an expert on US sanctions and the specific implementation, but when we speak about sanctions, I didn't highlight this because I'm speaking about force majeure here, but generally you have 3 possible clauses in your contract which cover that. The first one is an illegality clause, which says anything that would become illegal under the laws of blah, blah country, you don't have to perform. The second one would be a lot of contracts, maybe not a lot of, but some contracts have a sanctions clause, which say the moment there are sanctions, the parties are freed from their obligation. And really at the third level, does force majeure kick in? But usually a force majeure is the much more common clause in contract, and this is why I mentioned sanctions. Look, in theory, as Didi pointed out, in theory, you are free to still perform the contract and breach the sanctions. But legal impossibility, in other words, the impossibility to do something in accordance with the law, this is also considered as impossibility. It doesn't need to be factual impossibility. If you cannot access the port because it's destroyed by the tsunami, that's a factual impossibility. If you cannot access the port because of a lockdown, this is legal impossibility, if you want to say so. But both are impossibilities. And just one last word here on the US sanctions. I highly, and I should use 15 more highlies, do not recommend that you breach US sanctions, because this is really going to be painful.
Yeah, that's true. Yeah, that's correct.
Thank you very much for the answer.
Due to time restriction, we only can afford one more question from participant. Maybe to Donna Regina, you can deliver your question.
Thank you so much. Thank you so much, Kak Didi and Dr. Harald, for the comprehensive and insightful materials given to us. My question is actually quite simple. I am just, wondering what party will carry the burden of proof in proving the availability of the force majeure, frustration, or even hardship in the event of breach of contract. And since to the best of my knowledge, in Indonesia or maybe other civil law states, we have the principle of siapa yang mendalilkan, dia yang membuktikan, or the burden of proof is falls within those who postulate. So does this principle also applies in the force majeure, frustration, or hardship in the common law system, or even the international contract practice? I think that's all. Thank you.
I think you already answered your own question.
Exactly. I was going to say, why do you ask questions if you already know the answer? No worries. Yes, it does. This is a general principle. But think about it in practical terms. I'm always trying to forget about the theory and think stuff through in practice, because so often it gives us the answer. Imagine that you are based in Indonesia, you have a supplier, let's say in my country, in Austria, in Europe, and I declare force majeure. I say there was a fire in my factory. What are you going to do? Like, how are you going to prove that this did not happen? That's just crazy. You would have to come to Austria, then I would say, no, you're not allowed to enter my factory. It would be madness if the other side had to prove it. So it's always the party relying on that defense that has to prove it. Thank you.
Yep, I think that's all.
Thank you so much.
For participants, we come to the end of the Q&A session. Thank you, Dr. Harald Sippel and Ms. Dyah Paramitha for the lecture you have presented. We hope that the knowledge you've shared will be beneficial for us, and I hope discussion have been fruitful and insightful for us. Before we end our session today, to convey our highest appreciation, we present the certificate for our speaker that will be handed over virtually through the screen.
Thank you.
First, thank you, Ms. Dyah Paramitha. Thank you very much for the very precious insightful today. And also, thank you for Dr. Harald Sippel. Thank you very much, Dr. Harald, for the very insightful today. Okay, ladies and gentlemen, we have come to the conclusion of this webinar. On behalf of the host, I would like to extend our greatest gratitude and appreciation to our speaker and all participants for being able to participate in this webinar. We would also like to apologize for the mistake we have made during this webinar. As your Master of Ceremony, I, Selamat, would like to say thank you very much for being present today. We wish you a great day ahead. Wassalamualaikum warahmatullahi wabarakatuh. Good afternoon and thank you.
Thank you, Dr. Harald.
Thank you. It's a pleasure.
Thank you very much.
Thank you very much.
Thank you. Thank you very much. Hope you enjoy your session, Harald.
I sure did. Thank you.
Thank you. We'll always keep in touch.
Yes, please. Bye.
Sure.
please, by all means, I understand that Pak Gary will write Jenny, that you mentioned that.
Yeah, sure. Gary will always keep in touch with you too by email. Thank you once again.
Great. Terima kasih
Have a good
banyak.
day. Have a good day.
Bye-bye. Thank you.
Bye-bye. Thank you, Didi. Thank you, Pak Gary.
Thank you.
Yela, thank you, Pak Mursal. Thank you.